My name's Laura and I am here with Robin today, and we are discussing what to do if you are a landlord and you want to evict your tenant who has got rent arrears. So in terms of the initial part, so if I'm a landlord and I want to evict my tenants, do I need to serve the notice?
Thanks, Laura. It's your choice whether you want to serve the notice yourselves or instruct us to do that. A lot of experienced landlords are very happy to serve those notices themselves, but there's lots of things which can go wrong. So if you have any doubts at all, then it's sensible to instruct solicitors to do that for you. If there's a mistake in the drafting, or the wrong service method is used, or the tenancy deposit rules haven't been complied with, then a notice might not be valid and you'd have to start all over again. So if you instruct solicitors to carry out the notices, then we can advise on that from the beginning about what form of service is valid, and also help you collect evidence right from the beginning to prove that the notices have been served properly.
Okay, and let's say if I have already served the Section 21 notice, what would happen then?
We're very happy to come in at that stage. The first thing we would do is look at the notices and check that they are valid and check that everything's been done right. Sometimes a landlord hasn't served the tenancy deposit prescribed information correctly, so we would fix that and then serve new notices.
Okay. And let's just say that my tenant is in rent arrears, what could you do?
You have to be practical. If your tenant doesn't have any money, there's not much point pursuing them for the unpaid rent. Every case is different though. We'll look at the circumstances and advise you whether it's sensible to pursue possession based on a rent arrears ground. So if that does look to be the most sensible approach, we'll prepare the notices under ground 8. Where there is a real chance of getting rent arrears back, then we can put in a claim for that.
Okay.
And but if it looks as if there's no real prospect of recovering any rent, then we might not bother with that.
Okay. And wouldn't it just be cheaper for me to serve the notices myself?
If your tenant is not paying rent, then every month that they don't pay rent, you're losing hundreds of pounds in unpaid rent. And that means it's really important to get the notices right the first time around. You want to get a new tenant in as quickly as possible. So it might be a false economy to just do the notices yourselves unless you really know what you're doing. There's so many ways to get a Section 21 notice wrong these days. Maybe retaliatory eviction, or not having the right HMO licence, or not being up to date on energy performance certificates, gas certificates, or the how to rent booklet. With so many potential ways to go wrong, it's helpful to get advice right from the beginning.
Okay. And if I've already, so I just say I served the notice on my tenant and they don't move out, what do I do?
If the tenant doesn't move out, we can prepare the papers to issue a possession claim at court, and then the court will get in touch with all of the parties with a date for a hearing.
Okay, so if it does go to court, will I have to then stand in the witness box and be cross-examined?
That's not really how it works in a possession claim.
Okay.
We'll help you to prepare a witness statement, and we'll do that before the hearing. And if you had a managing agent who's been involved as well, we might need a statement from them.
Okay.
And we'll send those to the court, and the judge will read through them, hopefully before the hearing, and that means it's not really necessary to stand up and give evidence. We'll also instruct a barrister who does most of the talking in the hearing, and so there's not really much for you to do normally at the first possession hearing.
Okay. And will everything then be over at the first hearing?
If everything goes well, then the judge will make a possession order at the first hearing, and that's very good, but it's not the end of the process. If the tenant doesn't move out, then you would still need to apply for a warrant so that you can have a eviction carried out by the bailiffs.
Okay. So there is no guarantee that at that first hearing everything will be sorted?
First hearings are usually very short. So if the tenant submits a defence and that's got some merit to it, the court might decide that there's not time to deal with everything at the first hearing.
Okay.
So what that might mean is the court lists the case for another hearing, a bit longer, where the issues can be looked at in more detail. If something particularly complex comes up, such as a counterclaim for disrepair or a tenancy deposit counterclaim, the court might set directions, that's orders about how the case should progress, and then you'll have to follow through with them over the next few weeks before a trial.
Okay, and if I'm in a situation where I've been dealing with this up until that first hearing and I don't obtain an order for possession, what happens?
It's not too late to instruct solicitors, but it's really helpful if you get in touch with us as quickly as possible so that we're not scrambling to meet deadlines. You can save money by acting quickly and getting problems sorted before it comes to a trial or a contested hearing.
Okay.
So the best thing to do is take advice as quickly as possible. It's not too late to instruct solicitors even at that stage, so if you have a complex possession claim which you want some help with, then I'd encourage you to get in touch with the new inquiries team at Anthony Gold Solicitors, and we'll let you know about our services.